leave to appeal is granted. I'm trying to make sure that I am on the right track here. Leave to appeal is granted on what specific matter? Because Amapungane and their matter being dismissed at the High Court, that has been set aside, which means that Amapungane, the Constitutional Court is saying that the High Court should have not dismissed them. Instead, what they should have done is decide on the validity of their claim, and that's why the President is therefore ordered to pay the costs of Amapungane.
And that is correct, Paul, because remember, Amapungane's prayer was specific to the ethics code insofar as it applies to private donations to political party campaigns. So what the High Court had done was that instead of hearing the argument, the constitutional issue, the prayer, insofar as the constitutionality of the ethics code, they just dismissed it. So effectively, the Constitutional Court is saying that the court must hear Amapungane's case out. And I mean, if you look at it, if you look at what Amapungane is arguing, it's more in line with what is happening with the Political Party Funding Act. Now, that is encompassing and looks at the funding of political parties. So in effect, and simply put, they're saying apply that to political campaigns, private political campaigns. But more than anything, the court here literally agreeing with the full bench of the North Gauteng High Court insofar as their scathing findings on the public protector. I mean, the fact that they are saying that, which is what the court also said, the High Court said, that she literally rewrote the code. You know, to insert words into the code, it's almost unfathomable.
So, let's come back then to the matters around the public protector. They went straight to the Constitutional Court to appeal the decision of the Gauteng High Court, North Gauteng High Court, which set aside her report and the remedial actions therefore. What is the Constitutional Court saying about that particular decision?
Effectively, the Constitutional Court is agreeing with the North Gauteng High Court on those issues, except the one of Amapungane, that the public protector did not have jurisdiction to be investigating the private fund of the political fund. That the court's interpretation of what is included in the ethics code and what it covers, that it was correct. But also going as far as saying that for her to have reached, on the one hand, there was that, for her to have accepted on the one hand that the president may have inadvertently misled Parliament, and then by the same token saying that the president willfully
or deliberately
misled Parliament, that the two cannot be the same. But I think for me, what is most devastating for the public protector is what the court says about when she could not find, because remember the code is specific, and the code is also, it directs its focus on the work of the state, where it talks about the willfulness. So someone must have deliberately wanted to mislead Parliament. They're saying that she could not make that finding. And then to cover that, she wrote words into the code, which is, I mean, for a legal person, that is almost unbelievable. And also the Constitutional Court agreeing that they do not believe there was any evidence in front of the public protectors to suggest that the president willfully misled Parliament. So this is another judgment against the public protector. There are a number of judgments that have gone against her, and this adds to those judgments, and in effect it actually adds to whatever case. Remember that Parliament is in the process of looking into her fitness to hold office, following a number of scathing judgments. I mean, I can count the SARS rogue unit judgment. I can think of the I think the one on Pilay's
pension.
Pilay's pension. That is one of them. And then recently, actually, I had some of these cases here. But I think it just adds more pressure on the public protector, and I think it does not help. I mean, you heard what she said yesterday, where she ventured an opinion on the Zuma case that was just decided by the Constitutional Court, which I think is actually a dangerous thing to do for someone sitting in her office, given the fact that the public protector is not the person holding the office, but it's actually a constitutional body which is formed out of Chapter 9 of the Constitution. But anyway, I think the public protector, given the pressure she's under, she does play politics these days.
Yeah, yeah. The court also, Sbu, if you go back to the High Court judgment and the evidence that was heard there, at some point it is found out that the president, not only did he not know about the CR17 submissions or the CR17 accounts and what was going on in that account, but it actually goes as far as supporting the president to say not only did he not benefit personally, which is what the Constitutional Court is repeating, but that he himself donated towards the fund.
Now, that's another issue, Polly, because remember the public protector at some point led evidence that she got those anonymous emails, which actually disputed, because remember Cyril Ramaphosa's campaign managers had said that the president had kept a safe distance from all the donations. But evidence was led to show that there were emails where the president personally thanked some of the donors. But the court is saying that, be that as it may, there is still nothing to suggest that he had personally benefited from these donations. And going further, in the public protector rejecting his account, they're saying that she had no basis to reject the account he gave.
Yeah.
Because remember, Musima Imane's argument was that Ramaphosa's son had a, for a lack of a better word, shady relationship with African Global Operations, now known as Busasa. But the president answered that question in Parliament and said, yes, my son had a relationship with them. So the court is accepting the account of the president, where he came back to say, because it was the president who came back to say, I had been wrong, I had been misinformed. Actually, the donation was not to Andile Ramaphosa, but to the CR17 campaign. And the court is actually making the point that even though he had presented that, that argument, Musima Imane still did not accept, still did not believe it, in that in his complaint to the public protector, he was still saying that there seems to be a questionable relationship between the president's family and the company formerly known as Busasa. So they are saying effectively that she had no basis to disbelieve what he was saying.
Then the final element, Sbu, that I would like us to talk about is what the court says, because it's divided these into subsections. So on the competence to investigate the CR17 campaign, in other words, jurisdiction, the court comes to the conclusion that the public protector, in her remedial action, remember she says, she instructs the Speaker, the National Director of Public Prosecutions, and the South African Police Services Commissioner to carry out further investigations. The court is very clear that she had no authority to issue such an instruction.
Yes, that's correct. And then remember that not only did she instruct them to do that, but actually she had insinuated that the president may have been involved in money laundering, that there would have been a possible case of money laundering, which I guess then would explain why an NDP, why these parties thought to take this matter to challenge, to take it on review, given the fact that, for instance, I mean, it's almost unheard of to be telling a prosecutor who to prosecute. I mean, in terms of the separation of powers and the independence of the prosecuting authority, I mean, it would set a bad precedent to if any organ of state could tell a prosecutor what to do, where they are not to test the case based on its merits.
And perhaps to end this point, the court saying that the suggestion by the public protector that this 500,000 rands donation passed through a number of hands, a number of intermediaries, that in fact was never proven. In fact, it was not true. It only went through one account, and on that basis, the public protector could not have concluded that there was so-called money laundering.
Now, that's why the court also says that there is a scope within which to investigate. The complaint was limited to say, this is what you ought to investigate, but she had taken it further. But I must say, though, and it must be said for the record, that the public protector did have an ally in the Constitutional Court who found similarly to her. That is the dissenting judgment by Chief Justice Mogoeng, who also actually argues that there's a direct correlation between private donations and how they influence one's ascendancy to the high office, as to how you cannot distinguish between the two. It brings us back to the question of the ethical question of why the president should just disclose.